for fast lane services or access, while larger, more established companies can. Advocates also view net neutrality as a cornerstone of an open-minded internet and propose that it be mandated by law in the US to prevent broadband providers from practicing data discrimination as a competitive tactic. For example, several well-established social networks were created without much seed capital. Had they been forced to pay extra to be accessed at the same speed as competitors, they may never have been successful. So it's like the Facebooks of the world. Facebook started from Mark Zuckerberg's college dorm room. If net neutrality was not in place at the time, there would be no Facebook today. Certain advocates also highly push the agenda of a dumb pipe. What a dumb pipe simply means is that intelligence should only be located at the end of a network, known as the pipe, while the conduit itself should remain neutral. This is the dumb aspect of it. Advocates of net neutrality see municipal broadband as a possible solution to these problems. Without net neutrality today, regulators, proponents argue that there will be nothing to stop ISPs and cellular providers from limiting traffic from competitors, imposing even like an a la carte pricing for access to fast lanes, or forcing certain companies like online streaming services, so like the Netflix of the world, the Hulus of the world, etc., to pay more for bandwidth. Apologies, my screen is just frozen. I'm just trying to switch to the next slide. Can everyone see my screen, please?
Yes, I can.
Perfect, great. Okay, so like I was saying, moving on to the disadvantages of network neutrality. Some opponents of network neutrality include conservatives like think tanks, hardware companies, and major telco providers across the world. They suggest that by forcing ISPs to treat all traffic equally, the government will ultimately discourage the investments in new infrastructure and will also create a disincentive for ISPs to innovate. So let's look at it this way, right? The upfront cost associated with laying down fiber optic wires come at a cost. And these opponents of net neutrality look at these costs as very expensive and sometimes argue that them not even being able to charge more for that level of access will make their investments more difficult to pay off. Another possible disadvantage of net neutrality could be that the providers also argue that they may be allowed to charge tiered prices for access to remain competitive and generate funds needed for further innovation and expansion of broadband networks, as well as to recoup the cost already invested in broadband. They are largely of the opinion that this disallowance stifles growth and heavily discourages ISPs. So if you can see my screen, it's just a global map of the world showing the status of net neutrality across the world. The areas highlighted in light blue are territories where the net neutrality provisions are in place and protecting their jurisdictions. The areas in red are jurisdictions also considering these protections. The areas in gray are areas where net neutrality has not been enforced. There's no protectionary measure against this. Right, so net neutrality across the globe. We will be looking at, I've just picked a few countries, my mistake. I've just picked a few countries that I found quite interesting during my research. Some of them have adopted net neutrality to an extent, while some haven't. Some are in the process. So we'll start with the US, for instance. So in the US, the FCC, like I mentioned earlier, which is the Federal Communications Commission, actually instituted an open internet order. However, sometime in 2015, we saw that this order was rolled back by the FCC. Hello, can you hear me? Hello?
I can. Yes, I can hear you.
Okay, so like I was saying, in the US, given the importance of the internet to our everyday lives and socioeconomic impacts, the decision of the FCC has been subject of global discussion and critique. So ever since the rollback, the term has been the center of debate over internet regulation. The Congress, the FCC, and the courts in the US have all debated on whether this is necessary and how to protect network neutrality. Critics see this decision as a threat to internet consumer freedoms, economic competition, and even the progress of scientific research and knowledge discovery. I mean, I think that for one, we can also agree, seeing how important the internet is to the advancement of innovation, the development of human capital, and even economic growth is very imperative for technologists, researchers, and innovators alike to take heed of the policy debates and these latest developments as it impacts our lives in various ways. We would also be having a look at what's applicable in the EU. In the EU, sometime in 2019, net neutrality was presented to the EU Parliament and it was well adopted and received. Under the EU rules, ISPs are prohibited from blocking or slowing down internet traffic except when necessary. So these exceptions are limited to traffic management and to comply with legal orders or to ensure network integrity and security, and also to manage exceptional or temporary network congestions that may arise due to heavy traffic. So the provisions enshrined in EU laws are very end-user friendly, and it confers the right to free access and distribution of information and content. Specific provisions in these laws also ensure that national authorities can enforce these rights. So we also touched on Russia and Australia. You would think that with Russia, with all the heavy censorship that goes on in Russia, Russia will be heavily against net neutrality, but we actually saw that sometime in 2016, Russia passed its net neutrality laws. So I mean, I think people look at it this way, like a neutral approach doesn't mean that data is permissible. It just means that the government has the right to block access to a large number of sites. Another jurisdiction I wanted to touch base on was Australia. Now, Australia, very far off. People often joke and say that Australia is a world of its own, but Australia currently has no net neutrality laws, and it seems very unlikely to change anytime soon. ISPs in the country is regulated by the Australian Communications and Media Authority across the country. ISPs regularly offer zero-rated content through partnerships with content providers. So just to shed more light for people that don't know, zero-rated content here means data from specific apps or websites that aren't counted towards the user's monthly data limits. So it allows providers to forge partnerships with particular apps and websites, any of their choosing. So moving on to Nigeria, like we're all aware, the NCC is highly in support of net neutrality, and sometime in 2017, it released the Draft Internet Industry Code of Practice, also known as the Draft Code, that allows ISPs comply with global net neutrality policies. It's also important to mention that it's merely a draft code and hasn't been passed into law just yet. Now, this brings me to the second half of my discussion today, the ongoing debate on net neutrality versus net transparency. Some often say that net neutrality and net transparency are one and the same thing. One cannot happen without the other, while a different school of thought thinks that, you know what, net neutrality is a standalone, while net transparency is a standalone, and net neutrality is not achievable, while net transparency should be the order of the day. So like I mentioned earlier, in Nigeria, The NCC's position is quite obvious and recognizes that an open internet is key to innovation. It also acknowledges that other factors must be taken into consideration, including online child protection, for instance, privacy and data protection, objectionable consent, unsolicited communication, traffic management practices, etc. These are all considered necessary in order to maintain network efficiency. So pursuant to its powers under the NCA, which is the Nigerian Communication Act, the NCC has published the guidelines for the provision of internet services, which applies to all ISPs across the nation. The guidelines require all ISPs to comply with the Consumer Code of Practice regulations, which provides a template for the minimum terms and conditions for the provision of telcos and consumer practices in Nigeria. So like I mentioned earlier, the NCC also released the draft code in line with the upholding of net neutrality principles. The draft code acknowledges and provides for the consumer's right to an open internet and further guarantees the right to have unrestricted and non-discriminatory access to lawful content. So in accordance with this provision, the end user basically is free to send and receive information and content online and use the appropriate terminal device of his or her choice without restriction from any ISP. So under the draft code, ISPs are heavily mandated to be completely transparent by providing full and accurate technical and commercial information on their services and to make a full and fair disclosure of information regarding bandwidth. This is including whether the bandwidth is shared or dedicated to the user. So other sections of the draft code also seek to impose specific transparency obligations on the ISPs with respect to the performance, technical, and commercial terms of the internet access service in a manner that is sufficient for consumers and third parties to make informed choices regarding their use of such services. So from all of this, we see that the NCC is heavily pro net neutrality. So just to sum it up and bring me to a conclusion, the aim of net neutrality and net transparency is basically to balance the interest between ISPs and internet content providers by enforcing protections against content and application discrimination. It's quite evident that the NCC has done a thorough work as the neutrality provisions of the draft code are consistent with the global standard for net neutrality, which have been adopted in other jurisdictions. However, like I mentioned earlier, the draft code is yet to be passed into law and obviously cannot be implemented at this time. I'd also like to just bring to your attention that, as is the norm in other jurisdictions, the right of the service providers to adopt reasonable traffic management practices is also recognized and provided for in Nigeria. So this balance is highly, highly important to maintain and protect the reliability and optimal performance of network providers in Nigeria. So with this, it brings me to the end of my presentation. I hope we've all been able to learn a thing or two about the history of net neutrality and transparency. Thank you.
Thank you so much for such an insightful presentation. So our next speaker will be Mr. Solomon, who will be speaking on measures to protect customer information and accessibility. Over to you, Mr. Solomon.
Yeah, good afternoon. Thank you so much, Jessica. It's a pleasure to be with everyone this afternoon. Yeah, so I think first of all, I actually did something rather more expansive, which covers a whole lot of gamut of net neutrality. But be that as may, I realized that I'm actually limited to the application of privacy and data protection principle as it concerns net neutrality. Now, so the very first thing I need to also understand that now, generally, because internet service providers, during the course of doing their work, carrying out their duties, now they go out of their way to ensure that they deploy technologies that will actually make their work easier. For example, we have come across the use of a technology known as deep packet inspection. Now, that technology allows them to examine data traveling over the internet. Now, but while doing that, now the use or the deployment of that technology becomes so intrusive that it actually gathers personal data of internet users. Now, and when we look at it, now the concept of laws that govern net neutrality all over the world is to the extent that users' personal data and information must be protected. Now, and that's it. So, because when we look at it, while the internet service providers are actually doing their work, gathering the information, now their technology gets to be intrusive that it actually gathers information beyond what they need, which are personal data and information of users. Then what do we do? Then in that situation, we resort to the need to comprehensively protect personal data of internet users. Now, and in doing that, it has actually been established that the only way that can be done is to have a comprehensive data protection legislation. Now, as we all know in Nigeria today, we don't have a comprehensive data protection legislation. What we have at best, which is the Nigeria Data Protection Regulation, NDPR 2019, is at best a subsidiary legislation which is fraught with many inadequacies. So during the course of this conversation, now I will actually take us through the nitty-gritty of what have to be put in place for us to ensure that personal data of users are actually protected, in fact, comprehensively protected during the use of the internet. Now, so the very first thing is this. Now, we need to ensure that there is a comprehensive data protection legislation. I need to make a reference to Data Protection Bill 2020 that many Nigerians today we consider as the legislative hopeful to govern the concept of data protection and privacy in Nigeria. And there's a very dangerous provision in that bill. Now, I will take us to provision of section 35 of that bill. Let me be quick to say that my slide will be made available within the next 24 hours after this meeting, and of course, which will be so detailed to cover everything that is going to be discussed here. Now, so the first thing is that provision of section 35 of that bill states that the principle of privacy, data privacy, shall be exempted when some issues, come up. What are the issues? Issues of national security, public defense, public morality, public health, and all of that. Now, the challenge with that is this. Now, an internet service provider can just, for whatever reason, just raise an issue of national security. Particularly, all they need to do is to cite such national security by whatever means that, okay, because of that, they need to deploy a particular technology. For example, like I cited, the issue of the deep packet inspection on their platform. And when they do that, the likelihood is that people's personal or users' personal data, become a matter of risk. And when that happens, they know that they have a ready defense, which is an issue of national security. But we have come to a point that in violation or possible violations of people's personal data on digital platform, now it is not automatic to just cite national security. Now, whether that is being deployed by the government itself or through the ISP, now the provisions of the law have to be complied with. Even though as of today, we do not have a comprehensive data protection legislation like we all know, but we all know that provisions of section 45 of the Constitution of the Federal Republic of Nigeria, 1999, is very clear on the fact that when issues of privacy, among other rights, is to be threatened or violated, some things have to be established. The first thing is that can only be done by a law. Now, so the question we need to ask ourselves today is, what constitutes a law? What constitutes a law has actually been defined in a number of cases that it has to be an act of the legislature. So I'm going to share with you, there's a particular case which is a judgment of the Court of Appeal of Lagos State, or sitting in Lagos State. Now, that is the case of Abdul Karim versus Lagos State government. In that case, the court held that a directive of a governor shall not qualify under any circumstance, shall not qualify as a law because it is not an act of the legislature. So what we are saying here is that if for any reason, whether the government by itself or through an ISP or any of its agencies would deploy a technology that has a capacity to compromise users' privacy and data, now doing that has to be by a law. Now, yes, of course, I need to be clear here that the law we are talking about here sometimes may not come in the form of an act, may not come in the form of a law by House of Assembly, but even if it is by a regulation, yes, made pursuant or issued pursuant to a valid and existing act, an extant act or extant law, then it shall be interpreted to be a valid law. So the first thing we need to be sure is that while whatever agency or data controller, whether it is the ISP this time or an agency of the government like NCC, now is actually taking a position for whatever reason, we need to be sure that first, it has to be a law has to be relied upon in doing that. Now, some of us can remember, I think during the NSAS protest in 2020, some websites were reportedly blocked on the instruction of the agency of the federal government. Now, doing that cannot just be by direct of any minister or a DG of an agency. It has to be, in fact, when that decision is being communicated to ISP, they have to rely on a position or a provision of an extant legislation. That's number one. Number two, the second thing that has to be observed is that it must be in pursuance of a constitutional objective. Now, if we look at the provision of Section 45 of the 1999 Constitution, it is clear to the extent that when you need, yes, privacy, for example, and privacy, expression, and some other rights from Section 37 to Section 41 of the Constitution, they are not absolute. But then the position of the law is that they can only be restricted in strict adherence to constitutional provisions. And one of such provisions is that, one, like I stated, they can only be restricted by an extant legislation. Now, number two, even during the concept of the extant legislation, the provision of that law has to be precise, clear, and must be devoid of any ambiguity. What that means is that in any situation, the citizens must not be left in doubt as to what website they can visit, what activity they can conduct online that can actually constitute a violation of the law, that can actually expose their personal data to compromise. So a citizen, a user, needs to be notified by provision of the law ahead of time. Now, I must not be in doubt as to what act or omission on digital platform will constitute an offense or not. Now, so number two, now it must be, such a restriction must be in pursuance or in protection of a constitutional objective. Like I stated earlier, the ready defense for the government is always national security. Now, sometimes public health, sometimes public safety, the government bring up public safety, public health, and all of that. Now, if we could remember during COVID, now a good number of jurisdictions around the world, lawsuits were filed to enforce people's rights. Now, while doing that, most of the governments all around the world actually cited public health as their defense in violating people's rights, including right to assembly, even on digital platforms. Now, so in that situation, the position of the law is that such a restriction that will violate users' personal data on digital platform has to be in pursuance of a public objective. Let me give an example, which I need us to be able to relate to this. Now, the position of a court has been that, one, the data controller or whatever institution is responsible for restricting or violating personal data on digital platform now cannot just be a blanket position of citing a position in the Constitution. For example, national security. It cannot be blanket. Now, you need to put before the court a sufficient position to justify an imminent threat to national security. Now, one of such is if, for example, operation of a particular website now is likely to expose the national security of the nation to a whole lot of danger or threat. Now, so you need to, the government or whoever is responsible need to put before the court that these are the imminent threat to national security. Now, then the third one is that the restriction must not be excessive or out of proportion. Now, one of such, as such have been interpreted. Now, there's a particular case, Chike and DPP. The court held that the court shall not be a rubber stamp of the act of legislature or executive, but shall be the impartial arbiter to determine what is reasonably justifiable. Now, so because when we look at that section 45, section 45 says such a restriction shall be what is reasonably justifiable in a democratic society. Now, let's say, for example, now the federal government set up a website, and the website allows, or the portal allows the government to be able to access people's personal data. And in such a situation, there's no privacy policy, no provision of data protection officer. Then, of course, people's personal data are now exposed, to compromise or in an unchecked manner. Now, I'm going to give an example to that. Now, so sometime in 2020, now we discovered at Digital Lawyers Initiative that there's a particular portal of federal government that where people can apply for a particular fund. I think the federal government of Nigeria set up a fund of about 75 billion naira to actually aid Nigerian youth in entrepreneurship. Now, but we discovered that one, the website did not have a privacy policy. Two, the website does not actually have a data protection officer. Now, among other provisions of the Nigeria Data Protection Regulation itself. Now, so at the end of the day, now we went to court and we actually submitted before the court that one, failure to provide privacy policy that will stipulate how the user's personal data will be processed is actually an invitation to violation of people's personal data. Number two, even when my personal data is actually compromised, the law provides that there should be a data protection officer of the data controller, which is the platform now, the agency running the platform, that I can actually complain to. Now, we discovered that such also did not exist. And we went to court. Now, at the end of the day, the Federal High Court sitting in mark judgment in that case and agreed with us absolutely. In fact, the court upheld all of our 12 reliefs. Now, only that failure to provide privacy policy on the portal, it's a violation of the extant regulation, which is the Nigeria Data Protection Regulation 2019, and two, non-provision of data protection officer and details of an officer in that
Hello, everyone. I think Mr. Solomon is having some internet issues, so let's wait for him to join us shortly. Thank you so much. Hello, Mr. Solomon. Please, can anyone hear me?
Yes, I can hear you.
Okay, thank you.
Can you hear me?
Yes, we can. Welcome back.
Hello? Hello? Hello, Jessica, can you hear me?
Yes, I can hear you.
Hello?
Yeah, can you welcome back? Hello, Mr. Solomon, can you hear me?
Hello, can you hear me?
Yes, I can hear you.
Okay, great.
Welcome back.
Yeah, thank you. So if you can hear me, so let me just wind up here. Can you hear me, Jessica?
Yes, I can.
Hello?
I can hear you, Mr. Solomon. I can hear you.
I can
Can
hear
you
you.
hear me? That's it.
So can I go ahead, please? Oh my goodness, the internet is I hope we are not victims of net discrimination.
I hope so.
Can you hear me, Jessica?
Yes, I can hear you, but the internet is not just favorable. I don't understand why. But I can hear you. Okay, good afternoon, everyone. I think I will need to call Mr. Solomon to find out the possible solution to this. So I'll call him shortly right now. So then if he cannot join us due to the internet, Mrs. Simi can start our presentation. Sorry about that.
Hello, Jessica, can you hear me?
Yes, I can hear you. Welcome back, Mr. Solomon.
Okay, excellent. Thank you. Even though like I said earlier, I said that I hope we are not victim of net discrimination. You know, it's actually sometimes we live in a very volatile environment and things happen. So yes, so I think I should just wrap it up here. Now, the Internet Code of Practice, well, it's actually issued by NCC itself. Now, it makes two remarkable provisions on the concept of breach notification. So, and this is it. Now, the truth is that even the perfect, or there's no perfect system anywhere in the world, you know, for data storage, you know, and protection of personal data. Now, there are always cases of data breach in Europe, in America, and all over the world. Now, so, but the point is this. Now, the NCC has said that, look, in any situation, when there is an incident of data breach of an internet user, now, as an internet service provider, you have a duty within the law to notify the user within 48 hours. Now, and of course, beyond that, that ISP also has a duty within the law, now, of course, under the code, to notify the commission. Now, that is the NCC under 48 hours also. Now, on the issue of the incident of such breach. Now, I will tell you the instance of the importance or the relevance of that. Now, the truth is this. Now, the moment there's such a breach, because right to personal data, it's a right. So the user who is the data subject now, he has a right within the law to be aware that there's been an issue of breach to his personal data. So he has a right within the law to be aware. Now, what that does to him is that if there is actually a need to forestall further breach or further unauthorized access to his personal data, maybe on other digital platforms, then it can immediately take an action to prevent such. Now, and of course, the commission, which is the NCC also, in this situation, has a duty under the law to oversee such a situation, including remedies that actually have to be put in place. So, and this actually takes us to the place of responsibility on the part of internet service providers. So far so good. Well, I think the Internet Code of Practice actually appears very ambitious, but then we know the problem we have always had in our society is not actually want of legislation, but effective implementation of legislation. So we believe even strongly that the extant legislation we have, if they are actually given expansive and purposive application, then all the rights of an internet user, including right to personal data, will be sufficiently and comprehensively protected. I think at this point, I will want to hold it here and allow the third speaker to actually take over. Thank you, Jessica, and thank you, everyone.
Thank you so much, Mr. Solomon, for an insightful with the partner OAS more sorry about that. Net neutrality case study, and please do type in the Q&A, and after our presentation we'll be taking the questions. Thank you so much. Over to you, Mrs. Simi. Thank you so much.
Thank you so much, Jessica. Okay, can I share my screen, please?
Yes, you can.
Okay, perfect. Good afternoon, everyone. My name is Simi Salau. I'm from OAS Law. It's a commercial law firm in Lagos. So this afternoon, I'll briefly go over case laws and studies in net neutrality and what the future of net neutrality holds. Okay, so the first one case that I'm going to talk about was the National Cable and Telecommunications Association versus Brand X Internet Services. Just 1 second, please. Okay, can you hear me? Can you hear me? Okay, I think everyone's frozen. Can you hear me? Okay, perfect. Because I can't, Jessica seems to be frozen. Perfect. Okay, so this case, we had the situation where the Federal Communications Commission in the US. So this was the first case in 2002 that started this whole debate about net neutrality in the US. So this case was about a company that's Brand X Internet, who was suing the National Cable Telecommunications Association because they refused to allow. So the National Cable and Telecommunications Association. So this came to the Supreme Court. So this one I'm talking about was in the Supreme Court, but it started in the lower courts where they came to sue, saying that companies like AT&T were charging them for them to be able to use their landlines. So AT&T are companies that have cable lines in the US, and so they also tend to have their own internet service that they provide to their customers as well in the US. And then you have the private ISPs, that's internet service providers like Brand X, who also provide internet services. So what they usually do is they try to leverage, connect through their cable to be able to give internet to others through the telephone line. So because AT&T is an established company, they were trying to use their cable then, and AT&T would extort them by charging them as much as twice the cost of what it would usually charge. So which meant that these private companies, their own internet prices had to spike definitely to their customers as well. And when you have AT&T giving you 50% of what this other company is, obviously consumers are going to go to AT&T instead, right? So now this is when they came, and so they went to court to sue the companies that this is net neutrality and they need to make it fair and indiscriminating for everyone. They should not discriminate both the ISPs and users from using the internet. So now the FCC. So the thing about net neutrality in the US is it's been quite a back and forth, should I say, debate between the court, federal court, and states, and ISPs and consumers as well. So now you have the FCC, so that's the Federal Communications Commission. They tend to, depending on the political party in power, it tends to change. So during Trump's era, the FCC was against net neutrality. During Obama's era, it was pro net neutrality. So you will see, so this case, like I said, started everything. So as we go along, so this case had the court telling us that yes, the FCC can classify internet service providers as either information service or telecommunication service, or what we call communication carriers, common carriers rather. So the difference between these two, information service and telecommunications service, is that if you're an information service, the FCC cannot regulate you. You have to be a telecommunications provider or classified as telecommunications service for the FCC to be able to regulate the company or the ISP. So we have the situation where now this AT&T and Co. were now saying that no, they cannot be branded as telecommunications service providers, but instead as information service. In that way, FCC would not be able to control them. So this is how all the whole debate kept going back and forth. And like I said, depending on who is in power, it changes. So in 2010, the government then decided, okay, we're going to implement the Open Internet Order, which was created for net neutrality. In this, we have the case of Verizon Communication and the FCC, where it was ruled that the FCC had little power to regulate ISPs as far as they were classified as information services. Now, this Open Internet Order was meant to make the internet transparent to avoid traffic throttling and price privatization. And so, again, like I said, in 2010, as far as FCC kept classifying the internet providers, ISPs, as information services, they can't do anything. So this then led to 2015 when Obama was in. Then this Open Internet Order went ahead, and the FCC then classified ISPs as common carriers, now giving them the legal power to enact net neutrality protections, which were preventing ISPs from blocking or throttling legal websites, or from extorting other private ISPs, or asking them to pay for fees. We then move on to 2016, 2017, when Trump comes in. Again, we see that the FCC, recall, they actually reversed their earlier order, that's the Open Internet Order. They reversed it and said no, they're changing this ISPs back to internet service, meaning the FCC do not have any authority whatsoever over the transparency or the practices of ISPs. So now we have this Mozilla, that's I don't know how many of us then used to use Firefox. Mozilla was the one that owned Firefox, so they then sued the FCC because they were being charged as well. And as you can see now, Firefox doesn't really exist. It's not as strongly, you don't see Firefox like you used to then. And this is because due to the fact that so many internet providers they basically slow their traffic, and you can't really see them as a search engine. So they then sued then, and the court again had to rule that FCC cannot really do anything about it because they have classified ISPs as information services rather than common carriers. So we then go on to more recently in California. So due to the fact that FCC cannot do anything, you then have some states that have said, you know what, we are going to establish our own state laws to allow ISPs to allow net neutrality in our state and to be able to control the ISPs and net neutrality. So we have California. I think California and Vermont were one of the states that did so. So California in 2018 decided to pass this law, and the FCC then came and they tried to sue them through the Department of Justice under Trump's era. They came and they decided to sue the California state. And so what they argued then was that since the FCC doesn't have any right to authorize or to enact any laws or to prevent the ISPs from doing what they want, then California cannot go ahead to then implement their own laws, as the FCC trumps, because the federal law, it trumps the state. So this went back and forth until earlier on this year when Joe Biden comes in. And Joe is pro, like I said, depending on the party, Joe Biden is pro, and so he allows so he drops the suit totally. He actually dropped the suit, and so now California is going to enact their own net neutrality laws. So that means FCC as well will no longer have any authority again, because they've still not changed their authority over ISPs. But California will be able to rule their own net neutrality laws and make policies for that. Then we have the Netflix case, which is another very interesting one. Netflix, I'm sure most of us watch. I don't know how many most of us watched. All of Us Are Dead, and what's this other one? Squid Game. Yes. So those are very popular Korean shows that were very popular over the COVID period, and obviously due to the number of traffic that came on to Netflix, a lot of internet ISPs were like, no, Netflix needs to be sharing they need to be paying them to be able to use their services, because all the bandwidth that is going from the users using Netflix, and Netflix is getting richer, and all these people are using their internet service, and they are not really getting any benefit from it. So we have Korea in 2020 who actually, so they implemented this Telecommunications Business Act, which forced foreign companies, foreign content providers, to pay for network usage fees to local Netflix, to Netflix, basically. So that means companies like Netflix had then to pay them for the services. So now, sorry about that. Okay, so now we have so Netflix then sues the Korean company, that's SK Broadband, and tells them that since their consumers pay for their network usage, they should not be liable to any fees at all for using their network. The same thing happened in Netflix and Comcast too. Comcast was requesting for money from Netflix in 2014, and what they did was Netflix alleged that what Comcast was doing over their own network was that they were slowing down Netflix streaming service to their own consumers, which was causing problems for them. And so they wanted a Netflix to also pay them. So the thing about this is, if there are net neutrality laws, we'll see that all of this pay me for using my service and whatnot would not happen. But all these companies, all these rather countries, companies, they are not ruled by any net neutrality laws. They're able to tell people like Netflix and Hulu and all the rest to come and pay them to use their service. Now we come down to Nigeria. In Nigeria, a very good example actually is there was a time where the telecoms company wanted to actually ban Skype and WhatsApp. I don't know if any one of us remember this. In 2013, they wanted to ban Skype and WhatsApp and all these OTT, we call them over the top services. And so what they wanted to do was, they said they were losing a lot of money because WhatsApp was banning, was not allowing telecommunications again, making them make money to be making international calls. So definitely nowadays, I don't think anyone of us tops up to call internationally. We just go on WhatsApp and call. So this was making a lot of the telecoms company lose about trillions of naira, actually, then about 20 trillion naira. And so what they decided to do was to say, we're going to ban all the services on our network. And so people won't have access again. So let's just imagine if that had actually gone through. So all of us now would still have to be paying and topping up our phones to be able to call internationally. Thank God that didn't go through. So this is one of the advantages of net neutrality, as my co-panelists have discussed earlier. So this argument keeps going back and forth between pro and against net neutrality. We then have the draft order. Okay, so another example I have here is in 2013. Okay, you now have Airtel. So what Airtel decided to do, since they couldn't ban WhatsApp and Skype and others, was they decided to collaborate. And I think it still goes on now. People on Nine Mobile too. You get like free internet or so to use Facebook and some other things for you to stream. So what they then decided to do was to collaborate and bring a promotion with WhatsApp and Facebook and some other social media services, so that way is to attract some customers to be able to use the Airtel to use Airtel's service. Again, the consequence, it might seem, oh no, this is competition and whatnot, but the consequence of doing this is that people would then start using services like WhatsApp and Facebook, and we'll start ignoring the other messenger services that we have, for instance, Google Hangouts and Skype and others, because now Airtel is telling you with 1,000 naira you can chat or call unlimitedly or, on WhatsApp or on Facebook. So now we're already starting to have unfair competition in the industry, and this is one of the things that net neutrality aims to prohibit, unfair competition. So as the debate kept going back and forth, the NCC then decided to publish the guidelines for the provision of internet service, which Chika, I believe, spoke about earlier. So I wouldn't really delve into it too much. So the guidelines were to implement some net neutrality laws for ISPs and to protect the right of internet users to open internet, provide clear guidelines to ISPs on the use of traffic management practices, and for lawful content, application and services to prevent them from being blocked or made unavailable to some users. So that is where Nigeria stands at the moment. Again, this is still a draft and they're still seeking public opinion on what to do and when to implement it. As maybe time goes on and as this net neutrality debate is getting bigger and people are becoming more aware of what's going on, Nigeria will hopefully be able to implement it into law. At the moment, I think there are only about 6, as the last time I checked, there are only about 6 countries that actually had the laws, but there are about 50 of them that have like regulations or policies or rules for net neutrality in the world. And Korea, US, Russia, as Chika said earlier on, are some of the countries that actually have rules. EU as well, the UK, the US, they have rules. And like I said, some states have even gone further to implement their own laws. So what do I think the future of net neutrality will be like? Generally, the world is embracing net neutrality. Like I said earlier, it's getting more popular. We're talking more about it. And some people have decided to start implementing their laws, rules, or guidelines towards net neutrality. And there's a general support towards it, even though we have people who are against it, because they feel that the people, for instance, here we have MTN, who has invested about billions of dollars into their infrastructure in Nigeria, and they want to recoup money from that. And one of the ways they can recoup money is to tell people like WhatsApp, Netflix, and Hulu and co. to at least share some of the cost, because they are cutting them from some of their revenue, like for instance the international calls. So for those companies, telecoms companies, definitely they are against net neutrality. But for consumers, because apart from the financial aspect, it also decreases transparency, where it gets to the point that some of us would not have access, or some of our searches will be slower to us, or we can't even see some of the searches due to the restrictions that these telecoms have over our internet and what we can see. So like I said, the world is embracing it. Several countries have already put so many things in place. Nigeria as well is seeking to conform with international best practices. Even though it's a draft at the moment, we're hoping that in the future we're going to adapt it into our laws. And as the NCC is seeking a lot of opinions now, we can definitely give our own opinions as lawyers to be able to assist. In the coming years, at least in the next 5 years, I hope that to see more countries adopt it as well. California and Vermont being one of the foremost ones. Other states will start adopting it too. And hopefully the political parties, whether in Nigeria or in the US, do not hinder the advancement of net neutrality. So I think that's all from me. Thank you.
Thank you so much. Okay, I think we have a question. Someone is asking, is net neutrality really practicable in this world? And if no, why? I think that question is for Mr. Solomon. Hello, Mr. Solomon. Okay, since Mr. Solomon is not online currently, Simi, you could answer that. Thank you.
Okay. So do I think net neutrality is practical? Yes, it's practicable. Like I said, so there are already countries that are adopting it, about 40 something countries in the world that are adopting it already. Even though it's just, even some of them, it might just be a debate. For some, it might be just a rule or guideline. Yes, but again, there are risks involved with net neutrality, which Chika had spoken about earlier on. There are pros and cons. Definitely for the ISPs, it's not really a benefit for them, because then they can't charge the consumers or the other private ISPs for their services. The internet becomes open to everybody. Then even the government, apart from maybe for national security, they will not be able to restrict access to the internet as well for some things. So those are some of the reasons why some countries would definitely be against it. So definitely countries like definitely North Korea would definitely be against net neutrality, because they don't want that. And then you find out that maybe more capitalist countries as well will be against net neutrality. But we'll see as it goes on if that would change. But at the moment, yes, it's practicable, and hopefully more people will adopt it.
Okay, Mr. Solomon, you can say something.
Okay.
Asking if net.
Yes. So the question is net neutrality really practicable in the world, and if no, why? Now, to answer whether it is practicable, I would say yes. Is it possible? Sadly, I would say no. You know, I've actually maintained this, and I can say this with all sense of conviction, that government is the biggest violator of people's privacy and personal data all over the world. Now, and you see, it is so clear. Now, I'm going to give an example. So, 2021, I was privileged to lead some consultants that worked on Nigeria's data protection bill, but not just only that, that was just a constituent of the project. So what we did was that we actually worked on the project, advising European Investment Bank, World Bank, and French Agency for Development on the conditions Nigerian government needed to comply with in order to access funding for its digital identity project. Now, so why analyzing is Data Protection Bill 2020, which is yet to actually be submitted to the National Assembly. Now, we made comparison because, as a matter of fact, the funders, actually the development partners, they requested for us to, they requested us to analyze the bill and, of course, place it side by side with GDPR. Now, I will say this: national security, for example, is a legitimate concern any day, anytime, anywhere in the world. Now, first of all, we need to have a nation before we can talk about individual rights. That's right. But then, now, the what we have seen in practice is that the nations, governments now find it easy to wake up someday when they wake up on the wrong side of the bed that's talking about government officials now, to violate people's rights, all because somebody somewhere, an ally, a friend complained of something and thought, I need to deal with that fellow. Now, I can tell you categorically, the provision of Section 35 of that bill, God forbid that bill becomes a law. Now, the provision says, in case of data privacy, principle of data privacy, in case of national security, principle of data privacy shall be exempted. It's outright. You can't even come to us and talk about privacy. Now, meanwhile, in GDPR provision says, in cases of national security and some other cases, principle of data privacy may be restricted, subject to clear constitutional safeguards. You know what that means? Now, if NCC, for whatever reasons, needs to access personal data of some user, let's say in a place like Lagos, they need to approach the court, place an affidavit before the court, justify the reasons they need to actually access that. I'm going to give you an example. Now, there's a particular case which is Attorney General of New York and Facebook. Now, Facebook, Office of the AG of New York, now served a warrant on Facebook to investigate 185 Facebook accounts. Now, Facebook declined, citing one, you cannot use one warrant, search warrant, to search 185 buildings if you were going to conduct that in a physical space. Now, and Facebook as an entity is a global landlord of such to all its numerous subscribers around the world. So we owe them a fiduciary duty and we need to comply with the law. So there's element of particularity that your process lacks. You need to go back and actually get one such warrant issued for each of the 185 Facebook accounts. Now, when you look at that, that is actually a safeguard that Facebook was forcing New York, the government of New York, to comply with. Now, so what we are saying is that if you look at such the provision of Section 35 of Data Protection Bill 2020, now, if that bill becomes an act with that provision, my point, and I retrace, is that everything about data privacy or protection in Nigeria will become a joke. Someday when the DG of SSS wakes up on the wrong side of the bed, he would write a letter to them, see, he can access as many personal data as he wants. All he needs to do is to cite national security. Meanwhile, in Europe, you cannot do that. The regulations say may be restricted, subject to clear constitutional safeguards. There must be safeguards. They have to be complied with. They cannot just be complied with. They must be seen to be complied with. So what we are saying here is that net neutrality is practicable, but is it really possible? I think it's a question of what we need to wait to see beyond our hope and aspiration.
Thank you. Chika, would you like to add something to what Mr. Solomon has said? I think she's not on the call. Okay, we also have another question here. Can it be said that Blood said that then Timmy could say something about it also?
Sorry, can you come again?
Said that blockchain is contradicting or supporting the principle of net neutrality. Do you get me? question. I think I'm first. Hello.
Hello? Jessica, are you still there? Hello? Are you still there? I think you're muted. I can't hear you.
So sorry about that.
No problem.
So the question is, can it be said that blockchain is contradicting or supporting the principle of net neutrality?
That's a very, very, very good question. Okay, so we all know the way blockchain works, and the way it works is that it's all about secrecy and preventing and being transparent. And being invincible. So the fact that you cannot track it, for instance, the Bitcoin and whatnot around blockchains. So yeah, I would say that blockchain is actually against net neutrality, because the whole idea of net neutrality is for there to be transparency. And when we start having services or transactions which that are not visible to the rest of the people, and which again we can't even have access to that to be able to regulate them, because we don't know what's going on, the transfer of information, we don't know what's going on there basically, then it's not net neutrality. There's no transparency there. So blockchain is actually a hindrance to net neutrality.
Thank you so much. Mr. Solomon, would you like to say anything about the question? Hello, Mr. Solomon. Okay, I think he's not on the call, or I don't know, maybe the network. So there's also the last question here. Is there any provision in the Federal Competition and Consumer Protection Act interacting with the principle of net neutrality?
Is there any provision in the
Federal Competition and Consumer Protection Act interacting with the principle of net neutrality?
Absolutely. I think earlier on when I was talking about competition laws, especially where you have the Airtel example, for instance, where they were trying to make money while at the same time you were trying to side cut other types of social media services or communication providers. So definitely the consumer protection laws definitely come in place with net neutrality, because with net neutrality it's going to avoid so many anti-competition policies and contracts that do go ahead. I think another example in the US as well is oh, can I remember now? Okay, sorry, I can't remember. There was the one example that came into my head. I've lost it. But again, the Airtel one is a very good example, like I said. So it prevents all this anti-competition. So where one, okay, yes, I remember now, the AT&T, where they were now charging companies, where AT&T were charging other private ISPs from, they were charging them twice the amount that they would charge for their own internet to these private ISPs to provide to their own customers. Again, that is very unfair, and it's unfair practices. So definitely the Nigerian law, anti-competition law, it works hand in hand with net neutrality in that instance, because again, it allows for transparency, it allows for fair competition, it doesn't allow for monopoly of the market and other advantages.
Thank you so much, Simi. So we're coming to the end of today's webinar. I must say it was an interactive and profound section today. Thank you to our speakers for joining us today despite their busy schedule. I'm looking forward to seeing your subsequent webinar. A very big thank you to our sponsors, LLP, African Law Practice, FarmView, J. Alliance & Co., Advocate Law Practice, Ever Law Associates, DOA, and Blueframe for making this webinar possible today. Thank you also to our attendees for participating in today's webinar. Please do know that our next webinar series will be on Thursday by 1 p.m. and the topic is learning and development in the multi-generational workplace. Lastly, please do subscribe to our YouTube channel to watch our past webinars and more webinars at My Years to Legal. Thank you all for attending today's webinar and do enjoy the rest of your day. Thank you so much, Ms.
Thank you so
Simi
much
and
for
Mr.
having me.
Solomon. You're welcome.
Have a nice day. Thank you.
Bye.